What is the arbitration process in India? What are the different steps? What are the different stages? And under what situation would you even enter into an arbitration? So, hi everyone, my name is Ramana Reddy and I'm a practicing lawyer in India. On this channel, I help you by simplifying complex legal concepts. For tips, tricks, and general legal information, make sure you hit the subscribe button below. An arbitration is basically where two parties enter into a contract and they have something called an arbitration clause. And the clause says, look, if there's a dispute between us, then we will not go to the courts because the courts are busy, they are congested, they are overburdened with so many cases, and these things take years together in court. So, what both of us will agree is that in the event of a dispute, we will find a private, neutral judge who will adjudicate or resolve the dispute between the both of us, and the order of the private judge will be binding upon the both of us, and as though the order is an order of a court of law. So there is no way around that order. So it is not mediation where I'm free to walk away. Once the judge passes the order, that order has the force of law. But this whole dispute takes place, or this whole arbitration process takes place in a private setting. It does not take place in court, because most people feel, and maybe even rightly so, that courts in India are very slow. They're overburdened with several cases, and they just don't want to go to court, and they want a private thing where they get through the litigation process. So that is basically arbitration. So I think the easiest way to understand this is through an example. So let's take, for example, that you are a customer and that you have approached a painter to paint a painting for you, and you have a lot of money, and you say, look, painter, paint me this painting, I will pay you 10 crores. And you enter into the contract, say, on the 1st of January, and the painting is due within 4 weeks, say by the 1st of February. And in the contract, you have an arbitration clause where the clause says that in the event of a dispute between the customer, that is you, and the painter, then both of you will appoint, an arbitrator to resolve the disputes between the both of you. Now, let's say that 3 weeks in, so you have 4 weeks, right? He has 4 weeks to paint it. 3 weeks in, you find out that the painter has painted it. But now that the painter has received a higher offer from a third party, and that the third party is offering, say, 15 crores for the painting, and that the painter is trying to sell that painting to a third party, even though he entered into a contract with you to sell that particular piece of painting to you. Now, in that case, what do? Well, you're in a bit of a sticky situation because the arbitrator is not yet appointed, or this private judge is not yet appointed. So what you do is you go to the civil court. Now, I know you can say, Ramana, you just told me the whole point of going to arbitration is to avoid the courts. Yes, but the arbitrator is not yet appointed, and you want to protect the painting till the arbitrator is appointed, because the painting is sold. What is the whole point of arbitration? So you will go to the civil court and you will file something called a Section 9 petition. I talk about it in more detail. You can click here or here. And you go to the Section 9 court and you basically say, look, I have signed a contract with the painter. He promised to give me this painting. And now I have information from market sources that he's planning to sell it to a third party. So please restrain the painter from selling it to anybody. Because if the painter is sold, then there's no point, what am I going to fight for in the arbitration? If these are the facts, most likely the court is going to say, okay, Mr. Painter, deposit that painting with a third party, with an escrow, with somebody where the painting is safe. And after that, once the painting itself is secured, so for that you need to approach a civil court, file a Section 9 petition. Now, once the painting is secured, what you then do is that you issue a notice under Section 21 of the Arbitration and Conciliation Act 1996. You issue a notice saying, look, I appoint Mr. A as the arbitrator to resolve our disputes. Now, the painter receives the notice and he thinks, well, I don't know who this Mr. A is. And this Mr. A, who is supposed to be the private judge, he may be biased in favor of the customer. Otherwise, why is the customer even suggesting his name? So the painter may reply to the notice and say, look, I don't want Mr. A. I want Mr. B to be the arbitrator. Now we have a deadlock. How are you? Because both parties cannot agree on who is going to be the arbitrator. In such a situation, now you go back to court again and you file, but this time you go up before the High Court and you file something called an application under Section 11 of the Arbitration Conciliation Act. And there you say, look, we are not able to agree on the identity of who the arbitrator should be. So please appoint an arbitrator for us who will resolve the dispute about the painting. And the High Court generally has a roster, generally appoints retired High Court judges who have a ton of judicial experience, in dealing with disputes. And generally, a retired High Court judge is appointed as the arbitrator. Now, once that happens, the arbitrator issues notice to both parties saying, look, I've been appointed, please come before me. And the arbitrator, once both parties are before him, what he does is he issues something called a no bias certificate kind of thing, under Section 12, where he says that, look, I have no bias, I have enough independence, like I have nothing, like I'm not the legal counsel for one of the parties, So I have no conflict in taking up this arbitration. I am competent to take up this arbitration. And also, more importantly, I have the time to actually decide the case between the both of you. Then what he does is that he fixes a schedule for pleadings. So he will say, okay, you file your, so he will look at the customer, who is the aggrieved party here. And he will say, okay, you file your complaint by, say, X date. And the customer in his complaint may say that, look, I entered into a contract with the painter. The painter agreed to sell me this painting for 10 crores. And I find out that he's selling it to a third party. Please restrain him from selling it to a third party and compel him to sell this particular painting to me, because this painting is unique. There's only one such painting. So it's not like I can get a replacement painting. I'm not interested in damages. I want him to specifically perform. I want this particular piece of painting. So please compel him to sell it to me. So this could be the complaint, right? So he will say, okay, the customer, file your complaint by X date. And then he will say, okay, painter, file your answer, which is called the statement of defense. You file your defense by, say, Y date. And in which, in this particular example, the painter may say, look, I was ready to sell it to him, but in fact, the customer called and he said that he's not interested in the painting, that he wants to terminate the contract. And this was week 3 when I had already painted the painting. And I was literally forced to find another buyer. And that buyer is now offering only 8 crores. So I am basically at a loss of 2 crores, because originally I had agreed that he will pay me 10 crores and now I'm having to sell it for 8. I don't want to be just sitting on a painting like that, because I will lose money. So basically, I'm losing 2 crores here. So, he sues me, I'm going to sue him back. I'm going to counterclaim against him. And, he has, in fact, I am not due to pay him. I'm not due to give him the painting. In fact, he has to pay me 2 crores now because I have entered into another contract with a third party to sell it for 8 crores. So therefore, in fact, he's the one who should pay me money. And this could be the statement of defense. Now, at this stage, the arbitrator may also permit the claimant to say, if he's bringing up new facts that, that in fact that you're the one who terminated, then you can file a rejoinder to that and try to counter that, and to which the customer may possibly say, look, I just called him to say that I was running a bit tight on money, but I was still good for it. Like, I still wanted the painting. So I don't know how, in which possible world he could construe me being in a financially tight position for some time, that to be termination. I never terminated the contract. So basically, so what the customer files to begin with, the complaint, which is also called the statement of claim. What the painter files is called the statement of defense. The customer then can file a rejoinder to the statement of defense. If the statement of defense brings out some new facts that were not addressed, that were out of the scope of what the claimant had originally filed. Now, at this stage, the arbitrator will call both the parties and he will say, okay, look, both your, both your records or your pleadings along with your documents are filed now. So now we know what your respective stands are. And now we're going to draft questions. We're going to draft issues that will be answered by me as a private judge. Now, why do you need to do that? Because generally speaking, answers are only as good as the questions you ask. So in this particular case, the first question could be, is the customer entitled to the painting? The second question could be, did the customer terminate the contract when the customer called the painter and he said he was in a financially tight spot? The third question could be, did the painter properly mitigate his loss by agreeing to sell it to a third party? Fourth question could be, is the painter liable? I mean, is he entitled to the 2 crores from the customer because he's allegedly selling it for 8 crores? So these 4 questions will be answered during the whole course of the arbitration. And once the issues are framed, what happens is, now we have finished one stage of the arbitration, which is basically the pleadings. Now you move on to evidence. So now the customer, since he's the complainant or he's the claimant, he has to go first. So he will, on oath say, that all, 1, 2, 3, 4, 5 things happened and that he has to sell me the painting. And at that stage, something interesting happens, which is the lawyer for the painter will be given an opportunity to cross-examine the customer. So the lawyer for the painter might say, okay, isn't it true that you posted something on Facebook saying, I have ordered such an expensive painting, but I really don't have the money to do, I don't know what to do, and I'm very stressed out. Isn't that true that you actually had that Facebook post out? Or he may ask, isn't it true that your bank balance at all times has remained less than 10 crores? That therefore there is no way on earth that you could have afforded the painting? And so on and so forth. So basically, the painter's lawyer is trying to poke holes into the case of the customer. Now, once that is done, then we move on to the evidence of the painter. And now the painter is called into the witness box. And the lawyer of the customer, he is given a chance to cross-examine the painter. And he's going to ask the painter, you say that you have sold or so you've received an offer for 8 crores. But isn't it true that somebody has offered you 15 crores and that you are deliberately lying about the customer's termination because you could make an extra 5 crores on the other deal and you are looking to terminate this contract? Isn't it true that you've told Mr. ABC that this was the state of affairs? And these are the kinds of questions that the lawyer for the customer could put to the painter. And basically, so both sides are cross-examined and both sides are able to confront each other with whatever questions they have and try to, I guess, trap the other side into giving some admissions, which will, damage the case. Now, so this is the second stage of the arbitration. This is the evidence stage, and after cross-examination, and they may call, several witnesses on each side. But once all the witnesses are called and they are cross-examined, then the stage of evidence is closed. And then you move on to the third stage, which is the stage of arguments. Now, this is fairly straightforward, where both the lawyers stand up and they advance legal arguments based on the pleadings that are filed by the parties, based on the evidence and various admissions that were hopefully elicited during the course of cross-examination, based on documents that were filed. All these things are taken into account, and there is an argument that is made before the arbitrator as to why their respective clients should succeed. And after hearing both sides, the arbitrator passes an award, saying that either the customer is entitled to the painting, or saying that he's not entitled to the painting, saying whether the painter is entitled to the 2 crores from the customer or he's not entitled to the 2 crores from the customer. And this is an award that will be passed. So this is basically, so in this video, at least we've covered what happens pre-arbitration. So before an arbitration starts. So to protect the painting, you went to court under Section 9. You could not agree about the identity of the arbitrator. So you went to a Section 11 court. So this is kind of the before unit of arbitration. The during unit of the arbitration, Both of you appear before the arbitrator. The arbitrator gives a no bias certificate, a statement of claim is filed, a statement of defense is filed, a rejoinder is filed. Both parties adduce evidence, cross-examination happens, and arguments happen. And then an award is passed. So this is the during phase. Now, it is possible that the losing party may appeal the award and may be successful or unsuccessful, and the successful party will try to enforce the award, because what is the point of having an arbitral award which is just on paper? And we'll cover that in a different video as to what happens once you get the arbitral award and how you try to execute that video. Once you get an arbitral award and how you try to execute that particular award. But big picture, there's a before unit, which is section 9, section 11. There's a during unit, which is basically the arbitration, and then there's the after unit, which what happens after the arbitration is concluded. So I hope that video was helpful. If you found it helpful, make sure you hit the subscribe button below. Thank you for watching.